Employee Benefits Canada, Enhancing Retirement Security in Canadian Insolvency and Bankruptcy. Employee Benefits Canada, Introduction. The federal government supports the proposition that Canadians are entitled to a risk-free, safe, secure and sensible retired life. In recent times, corporate financial troubles have actually increased problems concerning the safety of pension plan, wage and benefit payments for employees and senior citizens. Employee Benefits Canada is now being looked at by the federal government. The most recent case that has brought these issues to the forefront has been the Sears Canada liquidation. Federal politicians have sponsored several private members' bills which have now caught the serious attention of our federal government. The federal government wants to make Employee Benefits Canada news. Employee Benefits Canada, my previous blogs. I have written on the issue in several blogs. Toronto Business Bankruptcy Protection, NDP wants federal insolvency laws changed so there is pension plan security when financially troubled businesses fail. September 27, 2017. Sears Canada is closing, the number one reason you have to run and not just walk to redeem your gift cards and credits. October 18, 2017. Sears Canada closing. Politicians want new laws to protect pensioners due to Sears Canada closing. November 1, 2017. Sears Canada defined benefit pension plan shortfall. MP Scott Duval comes through on his promise in Canadian Parliament. November 8, 2017. Corporate Bankruptcies Canada. Senator Eggleton proposes new Pension Fund Canada law. October 22, 2018. Arising out of certain policy statements in the fall 2018 budget, the federal government is looking for responses from pensioners, employees, firms, professionals and various other stakeholders in order to take a macro, evidence-based strategy to try to provide better retired life protection for all Canadians. Employee Benefits Canada, Canada's Retirement Income System. Canada's Retirement Income System, RIS, is currently based upon three columns: Old Age Security, OAS, and the Guaranteed Income Supplement, GIS, give a fundamental degree of retired life earnings. Canada Pension, CPP, gives standard a certain wage substitute for employees, funded by payments from employees, companies and the self-employed. Employer-based pension, defined benefit, DB, and also defined contribution, DC, and income tax-assisted personal saving vehicles, such as Registered Retired Savings Plan, RRSP, and Tax-Free Savings Accounts, TFSA. Employee Benefits Canada, Insolvency and Bankruptcy Law. In 2008 to 2009, the Bankruptcy and Insolvency Act, RSC, 1985, C, B3, BIA, and also the Companies Creditors Arrangement Act, RSC, 1985, C, C36, CCAA, was changed. Under the BIA, in a receivership or bankruptcy, arrears of wages was given a super priority. Approximately $2,000 per staff member must be paid in advance of secured creditors. Any unfunded normal employer pension plan contributions, as distinct from any unfunded pension liability determined by an actuarial evaluation, also have a super priority in either a bankruptcy or receivership. As far as a corporate restructuring proposal under the BIA, the amendment also states that the court cannot approve any proposal that does not provide for the same treatment. The CISA was similarly modified to be consistent with corporate restructuring under the BIA. Employee Benefits Canada, Corporate Governance. The Canada Business Corporations Act, CBCA, supplies the fundamental business administration structure for federally incorporated companies. Although good corporate governance is important for all business stakeholders, it must be followed and implemented to be of any use. As I indicated above, the Sears Canada liquidation has caused the federal government to now look at a variety of options to try to better protect employees and retirees for both pensions and benefits. Employee Benefits Canada, the feds are looking for stakeholder comments. The federal government wants to listen to the thoughts of stakeholders on what further actions that might be embraced to boost retired life safety for workers and senior citizens impacted by company bankruptcy. Specifically, the federal government wants stakeholder input on increased security for workers' claims and insolvencies, including changing the BIA and CISA to make sure that there is a super priority to pay unfunded pension plan contributions and benefits claims ahead of the claims of secured creditors. Many options are being considered that the federal government wants stakeholder comments on by the end of this year. Employee Benefits Canada, Pension, Corporate Governance and Insolvency Options being looked at. Pension Plan Options. Solvency reserves. A solvency reserve is an account the employer could contribute to so that pension deficits can be eliminated. I doubt this would work because if a company could afford to pay into a solvency reserve, they could also afford to just pay off the pension payment deficit over the same period of time. Pension plan financing relief. The Minister of Finance has the authority to offer companies with pension plan financing relief to assist in company pension. The Minister's authority could be boosted to assist companies with a pension plan deficit experiencing financial problems. This type of assistance, being a moratorium on pension payments, could come with specific conditions. Such special conditions could include a moratorium on the payment of dividends, share redemptions and senior executive bonuses, as an example. Self-managed accounts. Upon the bankruptcy of the company, the DB plan ends. In that case, the only option is to transfer each former employee's respective entitlement to purchase an annuity. So, the expected benefit will never materialize because of the underfunding. Federal pension legislation, and perhaps provincial legislation could follow, to provide extra options, such as the rolling over of each entitlement into a self-managed plan such as an RRSP, so that there is an opportunity to recoup some of the lost benefits over time. Corporate governance options. Limitations on the company. Dividends, share redemptions and senior management bonuses could be restricted under the CBCA in situations where a company is in arrears of pension contributions. Once the arrears are caught up, then such special payments could continue. As federally incorporated companies are the minority of all companies in Canada, the provinces would also have to invoke similar legislation in order to catch all corporations. An annual filing mechanism, perhaps through the Canada Revenue Agency, would also have to be established so that companies could be monitored. Bankruptcy and insolvency options. Increased look-back time. The BIA permits a court to reverse dividends paid or share redemptions made by an insolvent company within 1 year preceding the date of bankruptcy. The BIA and CISA additionally allow a court to invalidate reviewable transaction transfers at undervalue by the debtor as much as 5 years prior to the insolvency. In order to further connect corporate behavior with employee interests, the look-back period in the BIA and the CISA can be amended to include the unwinding of executive benefits, dividend payments and share redemptions at a time when there were also unfunded pension liabilities. The legislation could also be amended to state that the recovered funds must go to paying down the pension payment arrears. I would also go one step further to make the amount approved by the directors of the corporation to be paid out while there were pension plan contribution arrears a personal liability of such directors. Improved openness in CISA procedures. In CISA procedures, the borrower business can negotiate with its creditors on a debt settlement plan under court supervision. The legislation could be amended so that whenever there is an underfunded pension plan, it would be mandatory to have legal representation for the employees who are participants in such pension plan. This could be accomplished by amending the CISA legislation to require that upon the motion to obtain the initial order, the administrator of the pension plan must be an initial stakeholder that is consulted and served with the initial order motion material. The plan administrator has the statutory right to retain legal counsel and be represented at all court hearings. Employee Benefits Canada. The solutions are varied and complex. As you can see, the range of possible solutions is varied and complex. One thing is for sure though. The federal government has now awoken to the issue of shareholders being enriched off of the backs of the workers. The Sears Canada CISA liquidation has brought the issue to the forefront. It will be very interesting to see how the federal government proceeds in 2019 and to see how the insolvency landscape may change. Employee Benefits Canada. Is your company bogged down by too much debt? Is your company under fire as a result of too much debt, including pension plan contribution arrears? Is your business looking for reorganizing to obtain debt alleviation? The Ira Smith team has years as well as generations of experience helping people and companies in financial difficulty. If your company needs a corporate restructuring debt negotiation strategy, either under the BIA or CISA, we have the experience to end your stress, anxiety and discomfort. We will return you and your company to a healthy, balanced and efficient pain-free life. Our method for every case is to establish a remedy where starting now takes place. This begins the minute you consult with us. You're merely one telephone call away from taking the required steps to go back to leading a healthy and balanced problem-free life. Call us today for your free initial consultation.